What type of damages exist under a contract action, or what type of damages can a plaintiff recover for breach of contract by the other party? To start with, you have your compensatory damage. These are the actual damages that you suffered by not fulfilling the contract or the other party not complying with the terms of the contract. This is normally to represent the value that you forewent in this scenario, whatever profit you would have made or whatever additional cost you had to incur in order to fulfill or to continue on with the purpose behind the contract. So these are the actual damages that you incurred. Now, there's also a related concept called consequential damages. Now, consequential damages are damages that naturally flow from the contract. Now, these aspects were not specifically stated in the agreement, but it is readily foreseeable and a natural consequence of the breach of contract that you suffered these additional damages. So in a contract where you are going to supply me cement at a given price, you breach the contract and fail to deliver the cement, I have to go out and buy it from someone else and I pay a higher price. This is going to be the actual damages, and I will seek the difference in value there between what you were going to sell it for me at and this cost, and that would be your compensatory damages, the actual damages, the loss of value that you forewent under the contract. Now, the consequences from that is that I was delayed in the project, that I could not complete this part of the contract, and so I was fired from the future contracts, or I didn't get future contracts because of this situation. That naturally flowed from your breach. You had every reason to know that if I didn't receive the cement in time, that I would not be able to complete this contract in a timely manner. And it's a natural consequence that I wouldn't be hired on for a subsequent job. So again, I could be able to recover as a consequence there because it naturally flowed downstream. Now, in certain situations, a contract between individuals, it may be difficult to determine if a party breaches what the damages in that situation will or would be. So the parties can actually put a number in there and say, in the event a breach occurs, the breaching party will pay the other party this. And that's made to in some way represent the actual damages that the parties would suffer without having to try and calculate it afterwards. Now, as long as it's reasonable, as long as it somehow represents a calculation of what damages could be, and it's not just simply an amount made to punish a party, these liquidated damages clauses are fine. Okay, so the parties can knowingly agree on whatever damage is there.